Very good. So I welcome each one of you for the third day on the Housing Society Management Show. What we'll be doing is two important aspects we are going to discuss. The first one is related to RERA, Real Estate Regulation and Development Act 2016, and of course the developers' obligations, responsibilities, and then once the building is constructed, then the society is registered, and then the management of cooperative housing societies. As you are aware, due to the introduction of RERA, the management of cooperative housing society has gained momentum, and therefore there has been amendment done in the Maharashtra Cooperative Society Act, introducing a new chapter as especially for housing societies. Of course, that we'll be discussing throughout the day. Now, to start with, what we'll do is we'll go ahead with the complete question answer. And before I go with the question answer, I would request our chief guest of the day, Honorable D.M. Suktankar. I'll give only one or two introduction. He is the president of AGNI. Have you heard about AGNI? Yes. AGNI is Action for Good Governance Network of India. And last year, we had Confederation of Resident Welfare Association of India, Maharashtra Society Welfare, along with AGNI, we had hosted 5th National Conference at Ghatkopar. It was mind-blowing, and we had a very good program. And today, of course, we have second edition of Housing Management Show. Now, I request him, he is also the former Chief Secretary of Government of Maharashtra, and he was the former Municipal Commissioner of Maharashtra, and I think you were in the cooperative department also, no, but Municipal Corporation of Greater Mumbai, and his vast experience, and how he is relevant is he is also chairman of Housing Society where he is living. So with all this background, let us hear from him as to what is his, guidance or views regarding management of a cooperative housing society, where it is related to, as I was saying in the opening session, it is a grassroots level municipal corporation. If municipal corporation is talking about serving the citizen across a city, the housing society is a small grassroots level local democratic setup. So let us get some wisdom for 2 to 3 minutes, then we'll straight away open question answer on both the topic, management of housing society as well as waste management and RERA. Yes, sir, over to you.
Mr. Prabhu and friends, I'm not standing before you either as former Chief Secretary or former Municipal Commissioner or former Secretary, Ministry of Urban Development, and all kinds of caps that I wore during the course of my administrative career. I am standing before you as chairman of a housing society. And therefore, I know where the shoe pinches, because as chairman, I have to keep all the members together and try and get their involvement and cooperation in running the affairs of the society. And unless the management committee of the society enjoys the confidence of the members, it cannot really deliver and cannot succeed. The cooperative society management, I would divide into very broadly two parts. One is what may be called statutory compliances, that the Cooperative Societies Act itself expects certain things to be done by the managing committee and by the general body of the society, comprising all the members. For example, you have to send certain periodical returns. You have to send the audited accounts. You have to hold certain meetings in time. as per the periodicity laid down by the Act, and so on and so forth. So each society must have a proper calendar as to what are the statutory compliances required in each of the months. That is not very difficult to comply with or to implement. But provided you are keen to do these things as a matter of duty, which the law has enjoined on you. And that is the first thing, which is the minimum expected of a cooperative society, because all of us are supposed to comply with the law. If not, maybe certain other so-called good practices, etc., etc. So first is the legal compliance. And secondly, there are certain what may be called good management practices in order to ensure that the society's affairs are conducted efficiently in an economical way, without any friction amongst the members, and with the sole purpose of maintaining the building of the society in a proper state of maintenance and repairs, and giving to the members the kind of services which the society is expected to give to them. For example, water supply. For example, certain common passages and areas being kept clean and hygienic. Maintaining a fire-resistant and fire-fighting system properly in operation, and getting all the members to understand how it works, and maybe even periodically hold some kind of exercise for the members to actually respond to a distress call, as it were, and then what they are supposed to do and what they are not supposed to do. So those kinds of things are essential, and each member cannot deliver those societies for everybody else. And therefore, you create an agency or a mechanism like the society's management committee and whatever employees you may have to deliver those services: security, firefighting, cleaning, solid waste management, etc., etc. And each member, his responsibility is to comply with what the society management wants him individually to do, and only then can he expect from the society the collective services which everybody shares. So there is a give and take. You can't expect managing committee to deliver the maximum that you would like to expect from them, and not pay your monthly contribution, for example, or don't segregate your waste, and things of that kind. So it's a cooperative kind of effort where the individual members are aware of their responsibilities and are spontaneously willing to give their participation in the discharge of their individual responsibilities. And on the other hand, for certain collective things which are required to be done, the managing committee, on behalf of all the members, takes that responsibility. In actual practice, particularly when a person like me who is the chairman of a society which is exposed to the sea, I live on Worli sea face, and we have a major problem of corrosion because of exposure to the sea winds. So that is an additional problem in the case of our society, where you have to be very careful about preventive maintenance. Even if there is a minor crack somewhere, the sooner you mend it and fill it up, the better. Otherwise, it will seep into the core of your. you may have to spend later on about ₹1,00,000. So it is in your own self-interest to ensure that you undertake timely maintenance and repairs of your building. And from that point of view, it is necessary that every society, whether it is sea-facing like ours or anywhere else, must have a proper sinking fund. Because you know, whether you like it or not, every 10, 15 years, some major works will have to be done. And for that, every time to go back to the members and ask them to contribute for incurring that expenditure, whether it is replacement of the lift or some other major kind of thing. If we keep on contributing every month and build up a sinking fund, that comes in handy for such periodical, large-scale or structural kind of repairs which involve a fairly large outlay. And therefore, there are certain responsibilities of maintenance, certain responsibilities of security, certain responsibilities of collective services, keeping the common passages and areas in a habitable and sanitarily right position. So nothing very unique. Only thing is you have to sort of analyze, tabulate, prepare a calendar and ensure that both statutory and managerial or maintenance and repairs kind of responsibilities and keeping your building in a good state of living atmosphere, that is something which you do. And if you, fortunately, in our society, we are only 14 members. I know of societies which will have more than 100 members, and then all kinds of problems can arise, especially if members are not united, as it were, or they keep on fighting amongst themselves. That is one thing one must always avoid, because ego of the human being is always the biggest enemy of the human being. So there is always, when you form a society, it is implicit that there is a give and take. Otherwise, you would never have come together, isn't it? So the spirit of a cooperative society is a spirit of give and take, giving something for the betterment of the collective good of the entity, of the society. And therefore, that is all that is expected of the members. And try and avoid dissensions amongst yourselves, comply with the law, follow good practices. And I'm very happy, I was very happy to very quickly see 3 or 4 or 5 stalls in the exhibition. I would recommend all of you to have a look at that. I have no personal interest in terms of I have not put up a stall there. So, but nevertheless, to understand the various intricacies and the various detailed chores that a society is supposed to perform, and you will benefit from that exhibition. And that is all that I wanted to say, nothing very profound, but more on the practical side. Thank you.
What we'll do is, we'll open the forum for question answer straight away. You have any specific question would like to ask, either related to RERA or management of cooperative housing society? Any specific question? Yeah.
Good morning. What do you do when a member says that he will not pay his dues? And he says, you can take me to court, I'll also apply, get a lawyer. It'll take years. And that...
Okay.
1 minute.
And our society, I don't know.
No, 1 minute. The person is not a member, his father expired, it's 3 years, he's not given his share certificate for transfer, so he says, you can't do anything to me.
Okay. See, agreed. Suktankar sir has rightly pointed out. Ultimately, we are working together. Okay, it's a cooperative society where services has to be given to the members. Naturally, the member also is duty bound to pay the maintenance. It is not profit-making organization. Having said this, now if somebody is not paying for his own reasons, maybe father expired, share certificates are not transferred and all, the society has full right to recover that money under the section 101 of Maharashtra Cooperative Societies Act. There is a registrar where we can file the complaint. Even the High Court has given a verdict, and based on that, the new law is coming in, wherein on the occupier, you can issue the notice and you can recover the money from even the occupier. Occupier may be a legal heir, may not be legal heir, he may be a tenant, whoever it is. And if that occupier also does not pay the maintenance for the services that he is receiving, then you can evict him. So there is, after 101, there is another section called 156 of Cooperative Societies Act, where a special recovery officer is appointed by the registrar who will be able to take the possession of the flat and also auction the flat. So this normally does not happen. By the time you get the recovery certificate from the registrar, which happens within 3 months' time, from the day you make an application, within 3 months it happens. But problem is, the chairman secretary, they don't want to even to approach the registrar. What I suggest, if the dues are not paid for more than 1 year or 2 years, we need to issue a legal notice, maybe on the letterhead of the society, asking him to repay the money within 1 month, 2 months or 3 months, whatever, and thereafter issue a second notice. Even thereafter, if the money is not paid, please file an application before the registrar, who will conduct the hearing of both the parties, and if the other party does not come, it will be an ex parte order. Thereafter, the special recovery officer, which is empaneled with the federation, they will attach the flat and then recover the money. Initially, they will start with disposing the movable assets. Thereafter, they will attach the immovable assets. Even if somebody comes with the police and takes away the TV fridge from the house, you can imagine whether he will pay or not pay. Even the attachment notice which is put on the notice board and put it on his, on the door, that itself is sufficient for the family members to compel their earning member to pay the dues. So this happens. Only thing, we don't take a proactive step. It needs to be taken from the housing society. Okay.
Thank you. Thank you. You're one.
Including the expenses that you incur to recover and file the case are also being paid by the registrar. Again, you get 21% interest on the dues paid, whatever dues payable. So one need to pass a resolution and get it done. Okay. Thank you.
I would like to make a comment. I'm chairman of Pratiksha Worli CFS Cooperative Housing Society. We have made a rule that the member who doesn't pay his monthly charges, we will deny him parking space. Is it okay? Is it legal?
Sir, let me tell you honestly. You would like to comment? No. Okay. Let me honestly, I think Sunita Godbole also may come on the dais. She is head of the Women's Legal Forum for Cooperating Societies. Sunita Godbole, please come. Now, I really agree. Yeah, sir, no problem. So, the question is, can I stop any of the services that we are giving to the member just because he is not paying maintenance? The answer is absolutely no. Absolutely no. I'll tell you. You may say parking is not services that should be given. Let me tell you, parking is also one of the services given by the society. Lift is one of the services given by the society. Water supply is one of the services. These are all the services which is given. Just because somebody is not paying the charges does not mean that you stop giving services. I have seen the societies who do not lift the dustbin, whatever kept outside. Then what happens? Some people come, then they go on putting on the staircase. You don't want to lift? Okay. They also have that ego system or ego wherein they say, okay, you don't lift, I will keep all kachras outside my house. So it gets disturbed to others. How can you say that I will not lift the kachras from your house or the waste from your house? Secondly, you don't allow the parking, fine. You make the law. Can you ask your watchman to stop his vehicle to come inside? The moment you do it, he will also start slapping the watchman. You will lead to another thing. Law should not be taken in that. Some people do not allow the lift to be used just because they are not paying maintenance. The lift person and that member gets, fighting. Then it leads to the police complaint and a lot of things happen. What I'm saying, there is an easy method. What is the easy method? If a person is not paying, the law has provided, you go to the registrar is a regulator, he will issue the order within 3 months after going through your records. That's it. And the money that you spend to recover that also is being reimbursed. So why you are worrying about it? Why by stopping services like parking and other things, trying to irritate him? This is my simple question. Yeah.
Thank you.
Sir, any service. You may think that it is not essential for him. He is having a vehicle, so he needs to have the parking. So therefore, it is an essential service. So you cannot, according to me, you should not take law in your hand. You should not curtail the services which otherwise he was enjoying. And in fact, today morning I was reading an article. So in the Bar Association, it is a verdict of the Supreme Court. Now, what it says is, voting in the Bar Association, okay, by a member, whether it is a fundamental right or a legal right. The Supreme Court said it is a legal right. It's a statute right. It is not a fundamental right. So therefore, with a reasonable restriction, voting can be stopped. Similarly, now in the new law, it has been provided that if a person is not paying the dues and he is a defaulter, even after paying giving 3 months notice and all, then his voting right should not be allowed. Because it is a statutory right, it is not a fundamental right. Yesterday, there was a discussion in the same hall saying that how a fundamental right can be taken away when he is considered to be a member of the society because he is not paying maintenance. Certain restriction can be put on certain rights, but essential services should not be, curtailed. That is my submission. But actually, it is not an essential service. I agree with you, but it is one of the services. Water you cannot disconnect. You cannot disconnect the electricity. You cannot, not taking away the, dust or wastage from his house. You cannot stop the lift for him. You cannot put any, restriction in the entries and all. Same way, vehicle is one which is been parking in the society. I think it will create problem. This is my submission. Yeah.
No, as a supplementary, you were saying that if you approach the registrar, you will get probably a verdict within 3 months. Is it your experience that you get the verdict within 3 months?
Yes, sir.
Because many times administrative and judicial delays create an attitude not to approach that forum. Because, अरे वहाँ कौन जाएगा, वो 2 बरस में हमको verdict नहीं मिलता है, order नहीं मिलता है. They then resort to all kinds of shortcuts. So if it is happening within 3 or 4 months, it's great. I think society should, instead of resorting to shortcuts and trying to twist the arm of somebody through so-called essential service stoppage or inessential services stoppage, it is better to go by the law, what remedy provided by the law, rather than fighting amongst yourself. That is only my practical advice. Luckily, in our society, such a situation has so far not happened. Yeah.
Thank you. Here, there is one here.
Sir, in our society, certain people, more than 40% people have given their flats on leave license. Now, I have asked all the licensors to provide indemnity bond, because the problem is that in case of one member, at least I know for sure that he has taken bank loan for his flat, for his own residence, and then he has given the flat on leave and license. He has defaulted with bank also, and the bank has issued notice for taking the flat. Now, when bank takes the flat, then the licensee has already got in dispute with him. He is not prepared to hand over the flat. Now, if there is proceeding by bank, the society will definitely get embroiled. So, I mean, can I ask him to give indemnity bond for all the licensors?
Okay. See, the basic 2 things are more important when we are giving a flat on leave and license. One is entering into a leave and license agreement, which is to be duly registered. The second is the information of the tenant, which is given to the nearest police station. These are 2 essential things. As a, make it more, law-abiding, we also recommend that there should be one undertaking from the licensee saying that he will obey all the rules and regulations of the society. He will not, disobey anything. And if he does anything, the society will be in a position to issue him the show cause notice. After one show cause notice, he will vacate the premises. So this type of undertaking on 100 rupees stamp paper can be taken. Similarly, an undertaking what you are suggesting, an indemnity bond can also be taken from the licensor, that is a member, saying that he will also see that the tenants do not misuse the premises, they do not disturb the others, and if it is done, he will also ask the tenants to vacate. This type of indemnity bond can definitely taken, there is no problem. It all depends on the decision that you are taking in the general body. Any other questions? We'll stop there.
Yeah. Good afternoon. I'm Tarnikant Ghai from Malwani Asha, Malad West. I have a question. I think most of the members will agree with that. Recently, a case has happened with me. It was related to parking. And the case has gone to the court, and next hearing is in the month of May, wherein the lady has used a section 509 against the secretaries. So my question is, what protection the secretaries do have? Should we stop working as secretaries, as chairman or committee members?
Okay. See, I can only tell you, ultimately, the people, managing committee and the members are human beings. So, at the heat of the situation, as I was saying, that you try to arm twist your power and you do something which is not supposed to be done. And especially the parking is such a sensitive subject. And everything is a sensitive subject. You may be aware, just because a repair permission was not given, are you aware of this or not? The secretary was murdered in a cooperative housing society at Andheri. Are you aware of this? Yes. Just because he was murdered in the lift. My God. Just because a permission is not given for carrying out the repairs. So many secretaries have been slapped, chairmen have been slapped, and arm twisting happens, manhandling happens. I have been handling one or two society where the persons come with the revolver. Licensed revolver. Yes, he has a licensed revolver. He comes. And if anybody talks anything, he starts taking out the revolver. And I have myself witnessed. Because the general body was such a heated, this one, registrar asked me, can you go and handle the general body because repairs decision has to be taken. I said, no problem. And I was given a initial only, that these are the type of people who are there. I said, no problem. Licensed revolver person will come there. I said, no issue. I went, I took a police protection, everything was done, video recording was done, the person was there, the situation was also coming, but I allowed him to speak the way he wants. When I allow somebody to speak the way he wants, then after 1 hour, 2 hours, he has to cool down. Na? I said, you are all exhausted your points? Yes. Now let us go with the minutes. So or the agenda. What I'm saying is, sometime, this time things happen. So whether to work or not to work is their own prerogative. If there are 10 members in a society, 100 members in a society, who has to manage this? The elected representative. If somebody thinks that I cannot function there, better to resign and somebody else will come. When Indira Gandhi, shot dead, who thought who would come lead the country? But there are other people to lead the country. There are other people to lead the society. If nobody leads the society, then the registrar administrator will come. He will run for 1 year, 2 year, 5 year. Thereafter, the society will be liquidated. So, without the society, let the people manage their common affairs. Nobody can manage. So, there will be other person who will come forward. Don't worry about it. So, the person can resign if they think that they cannot go ahead with the this type of actions. Absolutely no problem. There are so many criminal cases happening. So many FIRs are filed against the chairman secretary. That does not mean chairman secretary need to resign. There are so many FIR filed by the chairman secretary against the member for something. I am aware of one society at Worli where, redevelopment was happening and the chairman and other committee members were doing something. One lady went and filed a case against him for molestation and other thing. And he was behind the bar for 7 days. Now he is out because that chairman was doing a little bit of dictatorship and others were not agreeing. That lady went and filed case and did so many things. And another society I am aware where the builder in one shopping complex, where he was not ready to form the society. A chief promoter came in and then he started doing the process. I was handling that matter. You know what that person has to do? He sent 2 people to his shop and made some argument. And thereafter, those 2 people who had went, they harmed themselves and went to police station, and that cheap promoter was behind the bar for 8 days. Now you tell me, don't you think who is right, who is wrong? The situation will say. That chairman became, or rather chief promoter became more stronger. After 8 days, he says, now that he has shown me, now I will see that the society is formed. Their family got together. They should be taught a lesson. That builder should be taught a lesson. We have purchased the premises. We want a housing society to be made, but our builder does not allow the housing society to be made. So how can, just because he is sending me behind the bar, I will not now step down. Sometimes this type of things happen. So that does not mean that we should be, leaving things for others' hand. We need to take a control. The chairman secretary should take call on that. Okay? I think we should go ahead.
I have got one question actually,
Sure.
Srimati, with a legal thing. So my mother, I lost my mother in April this year. She was 93, staying in a society in Worli. I lost my father a long time back. We have been applying to the society managing committee for transfer of shares, being the legal heirs. I've got 3 more brothers and sisters. We are 2 brothers and 2 sisters, all married, all staying separately. They refused to accept our application on 2 occasions. What they have to do is only the Form 17, they're supposed to sign the countersign and give us, and then they have to take a decision in the general body or in the managing company meeting. They refused to do that. We had to send it by registered AD. They accepted that. Then they invited us for a meeting. There is only a chairman and a secretary there who's a temporary secretary. The other committee members do not come there for meetings. The chairman is lady chairman. So last week they wrote us a letter that since this situation as per us is complex, we are going to take legal help and you will pay for that legal help. They never addressed our application for transfer of shares being the legal heirs. But they are saying that they will take legal help and we have to pay for that legal help. So they are just delaying the process for the last 5 months. So is it appropriate?
जनरली ये केस में तो ऐसे ही होता है, बट द सोसाइटीज ड्यूटी इज कि व्हेन योर मदर एक्सपायर्ड that time you have to give the application. You already given the application.
They refuse to accept it.
नहीं, तो
till we send it by AD.
Registered AD, right? तो ये रजिस्टर्ड एडी में देने के बाद भी आपकी मम्मी का डेथ सर्टिफिकेट दिया है,
सब दिया,
तो इंडिमनिटी बॉन्ड एफिडेविट न्यूज़पेपर में भी देने के बाद
अगर
वो नहीं कर रहे हैं, यू डायरेक्टली गो टू द डिप्टी रजिस्ट्रार. If they are not accepting your application, whatever the documents you have submitted, you go to the deputy registrar. They will call the hearing and you become the deemed members. तो उसमें they will take your other brothers and sisters NOC कि किसके नाम पे फ्लैट करना है आफ्टर
वो भी दिया है.
तो आपने डिप्टी रजिस्ट्रार को अप्रोच किया?
No, not as yet.
You approach to the deputy registrar. He will call the appeal. He will call the society members also, management committee. और वो 1-2 hearing में they will solve the matter.
Great. Now,
and there is no need if the fighting is not between your legal hair.
We don't have any fighting.
There is no need for succession certificate also.
Correct. They asked for that and they said we told them there is no need.
Indemnity bond and affidavit is enough for that. But you approach to deputy registrar.
Okay.
Your area, which area you are located?
I live in Andheri East in Marol, but my mummy used to live in Borivali IC colony, so they live there. So their flat is there.
You approach to P ward. I think P ward is for the Borivali. R ward, sorry.
R ward, yeah.
You write to deputy registrar. He called for the hearing. He called your society management committee member. He called you also. Or within 1, 2, 3 hearings,
but also when I talk on the phone to the chairman lady, or if she communicates in a meeting, she said, "अच्छा हम लोग करेगा, problem नहीं, लेकिन lawyer को hire करेगा और आपको पैसा देना पड़ेगा." She keeps on. Now they gave it in writing. We'll hire a lawyer and you pay.
No, you don't worry. You approach forum. We will do your matter.
Thanks. Okay.
One small thing. See, if at all you want to get your work done, and if the legal fees is coming to 3,000, 5,000, which is a reasonable fees, I think legally you are not required to pay. But in order to get your work done,
yes, sir,
if you are paying, when you go to the deputy registrar's office, you will have to spend at least 50,000 to 1 lakh rupees.
Correct.
Here, by spending 5,000 to 10,000, if you are able to get, if that advocate gives you adverse opinion, maybe then you can go to the.
Okay.
So maybe sometimes office bearers also feel that it is a inheritation property. There are certain legal complications can come. So we want to take a legal help. For legal help, why other members should bear for your internal things? So maybe if they are asking, if it is reasonable, I think you should pay and close the chapter then and there.
Okay.
If not, yes, then you can proceed to the register.
No, my issue is not paying that money of 5, 10 or 15,000. My issue is the managing committee, as per bylaws, authorized to ask a member's heir for paying a legal fee? That is my question.
Yeah.
They authorized as per the bylaws?
See, the reason is, I'll tell you. I'll tell you the reason.
Yeah.
Let us understand. There are 50 members.
Yes.
Okay. Now, suppose one member wants to sell the flat to another person.
Okay.
Then legal expenses are incurred, like making agreements, stamp duty, registration and all that.
Correct.
The documents are submitted.
Yes,
then
sir.
you pay 25,000 for transfer fees.
Yes, sir.
Fine. Now, one of the persons out of 50 expires. Now, legal heir comes and tells you transfer in my name. The society is not aware as to who is the legal heir, what is to be done, what is not to be done.
Okay.
They are not experts. Now they want to take the help of the experts.
Okay.
Why 49 people should bear the specific request of viewer to be dealt by a legal officer? So therefore, if that is the case, the managing committee has taken resolution. You pay, and if you think that that is a wrong resolution, go and challenge in the cooperative court. Be there in the cooperative court for next 10 years.
Correct.
You want to challenge that resolution?
No,
or
I don't
you
want to challenge. I'm asking whether it is appropriate.
Absolutely, it is appropriate.
Okay, then
according to me, it is appropriate.
Then you have answered my question.
Yes.
Thank you.
Yeah. Now we'll go to the 5 minutes we need to take on RERA. Because the subject was, RERA was also there. You are aware of Real Estate Regulation and Development Act 2016? Yes. Are you aware of this? Yes. Now, why this has come? Why this RERA has come? Can anyone answer me? 1 or 2 lines. Cheat builders. One, builders cheat. Secondly, regulate what? Regulate builders. So why they want to be regulated? Who is this? Absolutely. The first and foremost issue with the developer is they always go on keeping promises and they fail to keep their commitment. This Diwali, ghar milega, then next Dasra, ghar milega. After Dasra, next Diwali, Christmas, year end, next January. So they go on postponing the date. So there is delay in the handing over the possession. They don't keep the commitment of time-bound delivery. Then what else? So the monetary irregularity, they agree to give the flat for certain amount, maybe for 50 lakhs, 60 lakhs. At the time of possession, having paid 95%, then they would say that so much cash you pay, so much extra club charges you pay, 3 years maintenance you pay, so much you pay for parking. Otherwise, we will not give you the possession of the flat. We will cancel your allotment. By that time, 4 years, 5 years have been over. 95% of payment is with the developer. The rate of the flats have doubled. So now, in order to buy the piece, what you do is you are ready to pay the cash also. 20 lakhs, 30 lakhs, I have got this. So that means they don't commit or agree to the amount that they have agreed to deliver the flat. Third, most important, the siphoning of the money. The money is received for one project, that money is used for another project, that project gets stuck, the first project also gets stuck. Which means the money which has to be taken for a particular project has to be used for that project so that time-bound action can happen. Siphoning or diversification of fund is another major reason because they find money is coming, let me put in one project, from there he will take to another project, from another third project. If one of the project gets stuck, all 3 projects get stuck, and that is why the builders also are compelled to cheat. Anything else? The flat which is being sold to 2-3 people, same flat. Why? Because they want to come out of the crisis. The third and last very important is, even without plan, without the land title, you must be knowing about DS Kulkarni's matter, DSK group. You may be knowing n number of groups like Bhaktani, which are all in public domain, where the land is not in their name, flat is not in their name, approval is not in place, but they have got a very good brochure with the agreement wherein they will say, I will give this, I will give that, and then if I will give you assured return, all that promises without any title, and then the common buyer is cheated. So in order to see this, MOFA was there, Maharashtra Ownership Flat Act. It was done with the same purpose. The difference between MOFA and the Real Estate Regulation and Development Act is that in the case of MOFA, if there was any cheating or any violation, we were required to go to consumer court, city civil court, or maybe a magistrate court, initiate a criminal proceeding, but there was no regulator. There was no policeman or one who would, regulator who would stop, take a preventive action. Everything was codified. Everything was required to be done by the builder. He should give in time. He has to enter into an agreement once he receives more than 20%. He has to form the society. He has to give the conveyance. He has to, maintain the property. Everything was there. 3 years defect liability. All that is codified. He should give the plan. Without approved plan, he should not sell the flat. All this was codified. But if there is a cheating happens, the consumer need to go to the different courts, and we know what happens in the court. As Suktankar sir has rightly pointed out, will that happen within the time-bound manner? And if that is going to take so much time, it is better I not go into it, and then we lose the battle before we begin. In the case of RERA, a regulator is appointed. What is the duty of the regulator? The duty of the regulator is even before a flat is being sold or offered for sale or advertisement is done, the regulator should get the project registered, he should verify the title, he should get all the information, plan should be approved, there should be commencement certificate. Only thereafter, the regulator will register the project. Once the project is registered, he is given a registration number that is called MahaRERA number. Thereafter, he can advertise and sell the flat. Which means now, a government agency, a regulatory authority will ensure that everything is in place. So without those things, he is not allowed to sell. And if he sells, offers for sale, does advertisement, the penalty ranges up to 10% of the estimated cost of the project. Secondly, even after the direction is given to register, and if he does not register, there is an imprisonment of 3 years or 10% of the cost of the project or both. And if at all he is imprisoned and he wants to get compounding, then additional 10% of the cost of the project. Now tell me, if this is going to cost him not registering a project and selling, is going to cost him 30% of the cost of the project, he can be put behind the bar, then why a developer will not register the project? Having said that, once the project is registered, RERA says estate agent also need to be registered. A registered agent can only sell what is registered project. He cannot do anything else. Otherwise, there is a penalty to him also. Third most important is the money that is coming from the customer. He was getting diversified. If it is getting diversified, the law says the money should be put in a RERA designate account in a scheduled bank, and money can be used only for the land cost and building cost. Up to 70% of the money that is received should be put in a RERA account, and that money can be used only for land cost and construction cost. 30% can be used for other expenses. So the money comes 70% in the RERA account, 30% in the other account. That can be used the way promoter wants, but 70% has to be used for land cost and building cost. The next question comes, who will monitor all this? To monitor this, the RERA provides, the Real Estate Regulation and Development Act provides that the architect should certify how much percentage of work is done, engineer has to certify how much money has been incurred, and CA by going through the books of account should verify whether the land cost and construction cost has been incurred, and whatever money the chartered accountant certifies, only that money can be withdrawn from RERA account. Which means the builder has to incur the money first towards land cost and construction cost, then only that much money which is certified by chartered accountant can be withdrawn. If he withdraws more than that, and if it is not kept in the RERA account, the same will be audited once in a year, and based on that audit or the complaint, more important, 5% of the cost of the project will be levied as a penalty. Can you imagine what must be the penalty levied for an advertisement which is a RERA registered project, but the RERA number is written in a very small letter? What must be the penalty? In Maharashtra, MahaRERA has levied a penalty. Are you aware of this? The penalty is 50 lakh rupees. 50 lakh rupees just because the RERA registered project, but RERA number was not put prominently. Just because IOD document was there, IOD document was not uploaded, the penalty levied is 10 lakh rupees. Last week, A builder has been levied a penalty for what? Just because he has not registered the project, 50 lakh rupees. Do you know how many builders have already been penalized for not registering the project in Maharashtra or for various violations? Can you give me the figure? Can anyone give me the figure? Just rough figure, estimate. 1 builder, 5 builder, 10 builder, 100 builder, 200. How many builders? 200. It is 2,000 builders. 2,000 builders have been penalized in Maharashtra. And so far, the most important thing one need to look at it is that what was the issue? The issue was that our complaint was not getting heard by anybody. The RERA provides for 3 very important authorities. The first authority is Real Estate Regulatory Authority themselves. 3 people, chairman with 2 members, and there are 3 benches and where complaints are being heard. Today, more than 4,000 complaints are filed. More than 3,000 complaints are heard and disposed of. That's the speed in which the complaints are disposed of. In 2 months to 3 months, complaints are disposed of. What are the complaints? Complaints are very simple. Amenities are not provided. Position is not given in time. If the position is not given in time under section 18, from the day you have delayed, interest on the total amount paid by you will have to be paid to the consumer. So that means, suppose I was told that I will be given the position by 31st December 2016 and it is not given. From 1st January 2017, interest will start on the entire money that you have paid. And that too at the rate of SBI plus 2%. State Bank of India marginal cost of lending plus 2%. So that means the money is taken by the builder. He has not delivered the product. From the money that you have invested, entire interest on monthly basis you are going to get. It's very good. And there is a compensation. If what have been agreed is not given, one can go to the adjudicating officer. Who is the adjudicating officer? Not below the rank of district judge. And absolutely within 2 months the decision is given. Then if you are not happy with the adjudicating officer's order, you are not happy with the RERA order, then we go to the appellate tribunal. And even appellate tribunal decides within 2 to 3 months. The law provides for 2 months, but it takes about 3 months. So a lot of appellate matters are also disposed of. Then second appeal lies before the High Court. Believe me, from the RERA commencement till now, matters have gone to High Court and Supreme Court. It's already traveled. And the law has been established. The Supreme Court referred the matter to Bombay High Court saying that whether the RERA itself is a legal way, whether it is a constitutionally valid. To Maharashtra, it came to Mumbai High Court, and Bombay High Court has held within 2 months in the history that all the sections of RERA are constitutionally valid and it has to be there. It was supposed to be there long back, but now everything is settled and now entire India, more than 22 states and 7 union territory, nearly about 30 regulatory authorities already established, appellate tribunals are established, law is in place, and a lot of projects are getting registered, and I think it's a very, very important legislation to protect the interest of flat buyer, protect the interest of the consumer, protect the interest of the stakeholders, whoever, and the professionals are also made accountable and responsible. Even the matter went to High Court saying that whether an architect can be made accountable for giving a false completion certificate, yes. High Court said absolutely correct. Appellate Tribunal said yes. So even for, yes, for going to the, appellate tribunal is also very important. Now we will have another 5 minutes for question answer on RERA. Thank you very much.
Check.
Not more than 5 minutes? Yeah.
Is redevelopment members, that is those who are not buying flats, are covered, protected under RERA?
Okay. RERA says new flat purchases are covered under RERA. The existing flat owners, because they are negotiating with the builder, they are treated as a partners in the project and therefore they are not protected. But existing member takes a new flat by paying some money, he is covered. Existing flat owners are not covered as on today under RERA. You will have to go to the High Court. Yeah. Any other question? I think, thank you very much.
Very good. Thank you very much, Shri Advocate Ramesh Prabhuji.